Good morning to everybody. Welcome to the today class of this IIB. The today topic is that I am going to deal the law of evidence. I am sure that the people are hearing me. If you are hearing me, that what I posted on the screen, please read. Unmute and read what I posted on the screen.
Morning, sir.
Anyone.
An accident, staying down is a choice.
Yes, that is a good morning that I made it. The falling down is an accident. Saying down is a choice. Which one you want to prefer, that you can do it whatever you want. Of course, accident, nobody want to prefer it. And it is only the Uh, and we don't, of course, thanks, I will make it to a later part. Yes, in this class that I want to make it the All India Bar Examination, the Indian Evidence Act 1872, which I made it very much clear here. Then I would like to see that how the quick look because of that one, because I hided that one. The first question is, can you give me the answer for that one? Yes, read and give me the answer.
Sir.
Yes, very good, very good. It is in 1872. Whatever the second one, who was the founding father of the father of the Indian Evidence Act, 1872? Anyone, make a quick.
Stephen King, sir. C, sir. James Stephen, sir.
It is C. Is I wrote Stephen King, but you got
James Stephen, sir.
the right answer is the Indian Evidence Act is introduced as a standard set of law applicable to all Indians. The law is mainly based on the firm work by the Sir James Stephen. James Stephen, and who could be called the founding father of this comprehensive piece of legislation. The third question goes like this way. How many parts are there in the Indian Evidence Act 1872? Yes.
C, sir. Part 3.
This is the part 3. C is the right answer. I appreciate. In which part of the Indian Evidence Act 1872 is the maximum number of the chapters? Or in which part of the maximum number of chapters are there in the Indian Evidence Act? In which part the maximum number of the chapters, I said? Part 1, part 2, part 3.
Part 3, sir.
It is absolutely C. The part C is a very good answer. I appreciate it. And which section is repealed? The Indian Evidence Act 1872. Is it the section 1 or section 2 or section 33 or section 57? Answer is section 2, which is repealed over there from the Indian Evidence Act. Which section is the interpretation clause in the Evidence Act 1872? Interpretation clause, in which section it is made? It's section 1, section 2, section 3, section 4. Obviously, section 2 is repealed, so we can eliminate it. Now, the section 1, it is only the short title will be there. Then, generally, the interpretation clause, or we can say definition clause, which are generally in the section 2, but in some cases, it is section 3, but never it goes to section 4 in most cases. Yes, it is the answer is there in section 3, where the interpretation clause, that is nothing but a definition clause, is there in the Evidence Act, Indian Evidence Act of 1872. What do you call the interpretation clause, or interpretation clause is known as? Just before I give the answer for that one. Anyone? Just before I said the same thing there, right? I don't think that you need the explanation. See, interpretation clause also be known as definition clause or definition. Yes, how many schedules are there in Indian Evidence Act? Yes. How many schedules are there in Indian Evidence Act? There is no schedules. Of course, one schedule is there, it is repealed actually. Answer is none of them. Huh? Is it or not? Yeah, because the schedule enactment repealed by the Repealing Act of 1938, Section 2 and the schedule, both are repealed over there. So the answer is none of the above because no schedules are there in the Evidence Act. How many chapters are there in the Indian Evidence Act 1872? Chapters I am speaking. There are parts are there. Yes, very good. I appreciate there are the 11 chapters are there in the Evidence Act. The answer is B. Okay. Which chapter in the Indian Evidence Act 1872 is having the minimum sections?
Minimum 182, sir.
I say minimum sections. Which chapter in the Indian Evidence have a minimum section? If you see the chapter 11, there is only one section. If you happen to see the chapter 11, you could find only one section. I will show you that what is that section. Yes, it's the Bear Act. Only one section is there in the chapter 11. Yes. Now you can see that. How many sections are there?
182.
Is it the old sections 177, 167?
167 plus 15, sir.
What is 15?
167, sir. And then afterwards, 2000 added the 15 sections, sir. Total sections are 182.
Appreciate. So in the chapter 11, having the only one section. Huh? Okay, let us see that again going back to our point. Yes, the law of evidence is based on, is it common law, or English law, or traditional law, reasoning and logic? The answer is reasoning and logic. That is based on the reasoning and logic, that is the law of evidence is. Yeah, the word evidence is derived from the everyday
Latin
ra.
word.
What is that word? It is a Latin word. It's not a Greek word, not a French word, not a German word. Yes, quotation there. The evidence mostly signifies anything which demonstrates or increases the transparency and ascertain the truth of the fact or point an issue either in one side or the other side. Who said this quotation? This is regarding the evidence definition. Is it a Blackstone, or according to the Taylor, or according to the Bentham, or according to the Stephen? Anyone? Here it is Stephen. No, Stephen has given the different definition. It is a Blackstone definition. It is there. Stephen has given the definition. But anyway, the definition, please you read it because they are going to ask definitely in the examination. In which section the Indian Evidence Act 1872 states that evidence means and includes. Yes. Which section say about the evidence? Means and includes.
Yes, sir. Section 2.
See, I already told you section 2 is repealed and section 3 is the interpretation clause or definition clause. So all the definitions are there in the section 3. So anyway, that is nemo marturus prismantur mentri. This is the Latin maxim, and its equivalent English is nemo marturus persumantur mentri. Its equivalent English is, yes, anyone. A man will not meet his maker with lying on his mouth. That is the exact English translation. That equivalent is. But here a man I said, but in the second B I say a woman, and the third I say a person, and the fourth I say none of the above. But the answer is nemo mariturus persumantur mentri means the English equivalent is a man will not meet his maker with lying on his mouth. That means 17th question, nemo maritus personam mentri. This maxim in Indian law, it is a fact that it is believed that tell me, the same maxim in India, we will make it out in this way. A dying man can never lie. Truth
Yes, sir.
sits upon the lips of a dying man. Then both A and B. Then the D is none of the above. Answer is very much clear. A dying man never lie, and the truth sits upon the lips of the dying man. That means answer is both A and B is the right answer for that one. Based on that maxim, dying declaration is there. Now we will see what is that. In 213, a bench of Justice Deepak Mishra and R. Bhanumati and Ashok Bhushan said dying declaration should not necessarily be made by words or in writing, it should be through gestures also. Saigaltoni. Not just words, but even gestures can be made admissible in the court. Now it is observed in the case of a case law observe చేశారు. Even gestures also valid. In 213, love jihad case, transgender case, Nirbhaya case, Swami Ayappa case.
See, sir, Nirbhaya.
It is a Nirbhaya case because when I said dying declaration and made 213, then I gave the justices also at that instant that you can say easily the Nirbhaya case. Yes, what is the original name for the victim of the Nirbhaya case? Original name of the victim in the Nirbhaya case. I told in my last class is Jyoti Singh. Yes, come to the point of the 19th. The only statement that is given just before the death is dying declaration is spelled under which section of the Indian Evidence Act? That means dying declaration in which section it deals? That is the answer. Question. Section 32, subsection 1 deals about the dying declaration. That is the right answer. Okay, let us go to the next. When an injured person judges FIR, sorry, I repeat. When an injured person lodges a FIR, FIR means,
First information report.
is it only criminal cases or any cases?
Any cases, sir? Civil, sorry, criminal cases only, sir.
Thank you very much. Thank you very much. Yes. So, largest FIR then dies. It was held that the FIR will be relevant as a dying declaration was observed in the case of ఏ కేసులో మాత్రం అబ్జర్వేషన్ అయింది ఫస్ట్ ఎఫ్ఐఆర్ ఇచ్చిన తర్వాత చనిపోయాడు కంప్లైనెంట్ అది ఇట్ ఇస్ డీమ్ టు బి ఏ డైయింగ్ డిక్లరేషన్ అవుతుంది ఏ కేసులలో చెప్పారు. The case law which I given is State versus Ram Singh and another, and Mannu Raja and another versus State of MP, Biju Joseph versus State of Kerala, Pakala Narayana Swami versus Emperor. These are the four cases are there in under which case law that was decided where the FIR is given over there later part the person is died, then the FIR is deemed to be the dying declaration. It is observed in the Munna Raja and another versus State of MP. That is the right answer. So now let us see the next. The which section of the Indian Evidence Act 1872 says it about the electronic evidence? Yes. Here on the screen I already shared, and I am sure that you could see them because I made them big also. Yes. Yes, now you can see them. I made them big. Which section of the Indian Reserve Act 1872 says about the electronic evidence? The answer is section 45, capital A. It is said that the electronic evidence also be taken into consideration now because of this pandemic. Even electronic, even virtual classes and virtual hearing, virtual evidences, they are taken into consideration because of the advancement of the IT technology, that is the information technology. Now it can be taken as usual without any corroborative evidence also. So that is the reason we can say section 45 capital A. Why I should say capital A? I already gave the explanation in my last class. Whenever the new section will be added in the middle or to this particular section, there is no scope for that one, then the capital A, the letter would be added. If they want to add more, then a capital B, capital C, capital D. So in that way that you will go over there. Yes, come to the next point is in criminal proceedings, the fact that the person accused of a good character is irrelevant. Under which section of the Indian Evidence Act 1872 says, on the good character in the criminal proceedings will be considered as a proof, as evidence. Which section says? Section 52, Section 53, Section 54, Section 55. Which is the correct section where the good character is considered as a proof under the Indian Evidence Act 1872, Section 53. Suppose if you find the good character in the victim who is undergoing the sentence, in which date that he will be released by looking his good character from the jail? Yes, even though it is not there in the screen, it is a subsidiary question. Anyone can unmute and give me the reply. First, let me tell you, did you understand the question? I asked the question. Suppose if a person is undergone the punishment in the prison for 7 years or life imprisonment, but because of the good behavior, he will be released from the jail, from the prison on particular date. Which date it would be?
Sir, that is Independence Day, sir.
Not exactly. October 2nd, mostly. Okay, come to the point. The court shall not take the judicial notice of the following facts. I repeat, the court shall not, I say not, take the judicial notice of the one of the following facts. All laws in force in the territory of India, they will be taken into consideration as a judicial notice. The existence, title, and national flag of every state are sovereign recognized by the 10th Amendment, I think. The government of India, it will be there. Then among the four, that one is not, that is the territories outside the dominion of government of India. It should be the territories inside the dominion of India will be considered, but outside it not be considered the judicial notice. But the fourth one is the rule of the road, that 11th, the land and sea will be considered as the judicial notice of the under the. Yes, there is a section also there, but I did not ask the section and where it can be made. Okay, let us see that. Refreshing memory. Of course, the subsidiary question is under which section it will be taken into consideration. That is the subsidiary question. Then the next question is refreshing memory is dealt in the section of the Indian Evidence Act. First, you tell me what is meant by refreshing memory. Can anyone unmute and give me the answer? What is meant by refreshing memory is a subsidiary question. On the screen which I mentioned is which section deals? Answer is section 159 deals about the refreshing memory. But what is the refreshing memory? It means suppose a doctor has given a medical examination, he did it in a rape case. And a doctor will be called to make the to come to the court and give what is given in the medical report, because after the 1 year, 2 year, 3 years, he could not remember it. So he will ask the court, can you give me that paper which I wrote my medical report to refresh my memory? Because there is a gap would be there. He issues so many medical certificates in the criminal cases are, then which case which belongs he could not have it. Hence, he will refer the paper with the permission of the court. That is said to be the refreshing memory. Is it clear? Even including the witness also. Suppose the witness also given, suppose he want to make it whether it is a proper or not, so he will ask the other person, the court to give that thing which I gave the earlier statement, so that he could refresh his memory. Not only that one, but if a person A and B, and A saw a murder, and A wrote in the diary, and B saw that the A is writing the diary and A in the diary. At that instance also, B also come to the witness box. B will say that, let me see the diary which is written by A so that I can refresh my memory. So in this way also, section 159, refreshing memory comes. The subsidiary question will ask, refreshing memory means they will give 1, 2, 3, 4, A, B, C, D. You took which one is appropriate, unless until you know what exactly the refreshing memory is. Yes. And question 26, burden of proving that person is alive who has not been heard for the 7 years, spelled in the which section of the Indian Evidence Act? Yes. Because if a person could not be heard more than 7 years, the presumption is he is no more on the earth planet. In other words, he kicked the bucket. That means he died. Which section says? Section 108, that is the 108 says, the Indian Evidence Act, that is, if a person will not be heard more than 7 years at the time, that the presumption is that he is no more in this world, that is the section 108 says, the Indian Evidence Act 1872. Yes, which is which are not the four type evidences by which facts can be proven or disproven at trial. Please read once again and check what it is written over there. I say, which is are not the four types of evidence. There are four types of the evidence should be there generally. So real evidence, demonstrative evidence, documentary evidence, and testamentary evidence, testimonial evidence. Which one is not the? Yes, I think is the demonstrative evidence. To me, testimonial evidence is not the four type of the evidences because it is a documentary evidence. In that category, it will come. So we can say that testimonial evidence will not be considered. Anyway, please check it subject to the correction if the evidences are there. So how many type of the evidence generally will put? Because people will give the evidence in the oral form, people will give the evidence in the written form, or documentary form, or title form. Huh? Is it not?
Sir.
Yes, yes. So secondary evidence means and include it is a certified copy is given under the provision hereinafter contained. The copies made from the original by the mechanical purpose processes by which are themselves themselves ensure the accuracy of the copy and copies compared with such copies. Then copies made from are compared with the original and all of them above. And here the answer is all of them above are said to be the secondary evidence. Means original certificate duplicate copies or its Xerox copies are said to be the secondary evidence. So then feedback is primary evidence is dealt in section 62 and secondary evidence in 63 of the Evidence Act which will there. Then what is meant by primary evidence? This is not there on the screen. Yes. 62 if you happen to see, then you will know which are comes under the primary evidence, the original records. Even man himself, a eyewitness who comes to the court and gives the evidence, can you say is the primary evidence or the secondary evidence?
Primary
Yes,
evidence, sir.
because he himself come originally he saw it. Of course, hearsay evidence may be the secondary evidence. Are you following me? Please check it whether what I said is the right or wrong. So facts which, though not in issue, are so connected with the fact in issue, also to form part of the same transaction, are relevant whether they occurred at the same time and place or at different times and places is spelled under the section of Indian Evidence Act, which section says that facts in issues are, in other words, we can say register. Yes. The sequence of the fact belong to the same transaction. Suppose if he wants to murder a person, so he went to the shop. He has purchased a revolver. Then he purchased the ammunition. Then he brought in the second day and loaded in the third day and shooted him the fourth day. These are all relevant facts or not relevant issues. Hmm? So
Section 3, sir.
no, section 6, it will just about all the things. It is nothing but just which is runs from the section 6 to Section 9, regesta. That means, it's the Latin word which means things done. Res gestae means things done. This is the rule of law of evidence, and it is an exception to hearsay rule of evidence, that hearsay evidence is not admissible, and it is a direct evidence is there which is in a issue, it is admissible because the relevancy is there. It is spontaneous declaration made by a person immediately after an event and before the mind has an opportunity to conjure a false story. So the red gesta is clearly mentioned because the fact and issue are very much relevant. It is not connected with one another, but is purely connected to one another. Hence, it is a rest just section 6 will deal it. Section 6 to 6, section 9 of the Indian Evidence Act deals about the register. But the register is criticized by the subsidiary. The register was criticized by the Professor Stone, where he said, no evidential problem is to be shrouded, but shrouded in doubt and confusion. That is, he said regarding the register. But in the opinion of the Professor Wigmore, the rule is not only useless but also harmful. But they say regista is a rule which is not only useless but also harmless. So naturally, if every statement or every section or everything, there may be the different views. Like a knife, keeping a knife is a dangerous or keeping a knife is a safe. Yes.
Depend upon the sharpness.
So depending upon the sharpness, we can decide that whether to keep the knife or not. A knife can be used for chopping the onions. A knife can be make a slit to the larynx. What is larynx?
Sir, circumstances, sir, I think so.
I give the example. A knife can be used for the chopping the onions, or a knife can be used for the to make a incision or a slit on the larynx. ఏమర్థమైందండి మీకు?
To
ఆ గొంతు నాళాన్ని కొట్టడానికి లిరింగ్స్ అంటారా? ఏది గొంతు నాళం ఉన్నది చూడండి, దాన్ని ఇంగ్లీష్ లో లిరింగ్స్ అంటారు దాన్ని. అయితే ఆ చాకుతోని గొంతు నాళం కూడా కోయొచ్చు, ఆ చాకుతోని ఆనియన్స్ కూడా కోయొచ్చు, డిపెండింగ్ అపాన్ ద వే దట్ యూ వాంట్ టు యూజ్ ఇట్, వెదర్ ఇట్ ఈస్ ఎ గుడ్ ఆర్ బ్యాడ్. అండ్ ఎలక్ట్రిసిటీ ఈజ్ ఏ గుడ్ మాస్టర్ అండ్ బ్యాడ్ సర్వెంట్. ముట్టుకుంటే బ్యాడ్ సర్వెంట్ అవుతుంది, గుడ్ అంటే ఫ్యాన్ నడుపుకోవచ్చు, ఇంటర్నెట్ నడుపుకోవచ్చు, వైఫై నడుపుకోవచ్చు. ఎస్, టు కాన్స్టిట్యూట్ అడ్మిషన్ the following characteristics are to be present as a as per a definition stated above. So to constitute the admission, the following characteristics are to be present as per a definition stated above. So now we will see that what is the definition stated above. It may be a oral or documentary admissions. It is a statement to suggest any interference to any act in issue or a relevant fact which must be made by the any person prescribed under any act or all of the above. The admissions can be made orally. Admission can be made in the interference with the issues that are relevant. It could be made in the prescribed form. Then the answer is all of the above. Admissions. So now the next question is, admissions and confessions are dealt under the Indian Evidence Act. Is it true or false? Answer is true. So admissions and confessions are dealt under the Indian Evidence Act 1872. Now can you tell me which section respectively deals the admissions, which section respectively deals the confessions?
Sir,
Yes.
admissions are 13 to 31, sir. Confessions are 24 to 30, sir.
Please check
Sir,
it with.
admissions are 17 to 13, 23, sir.
Yes.
Admissions.
Yes.
Admissions are 24 to 30, sir.
No, they say 80. Confession. Anyway, check it whether I am right or wrong, because when I typed the thing, because when I said, let me check it whether it is true or not. See here, I made it open. Indian Evidence Act, Bear Act. Where is the Bear Act? Yes. If you happen to see the Bear Act, what actually given 80? Because I downloaded, I think, the old act it seems. This is. Presumptions as to the document produce a record of evidence. They say presumptions, they say. It is not a confession. So I think that your is right, I believe. See, the presumptions is given 80. But in the explanation, they have given a different thing. So let me check it, what is there given. Admissions are defined under the section 17 of the Indian Evidence Act 1872. An admission is a statement, oral or documentary, or contained in the electronic form, which suggests any interference as to any act or an issue or relevant fact, and which is made by any of the person and under the circumstances here and after mentioned, section 17 to 23. But please check it whether because I properly made it or not, because I wrote a wrong way, I believe. So please check it out where the confessions will come. Yes, you make it that thing where the confession starts, as you said. Does it start from 24?
To 30.
Is it 24? Okay,
24 to 30, sir.
let me check it. Let me check it. Yes, is a 24. Okay, 24. This is, yes, confessions. Yeah, you are right. Now, yeah, confessions caused by the inducement, threat, or promise when irrelevant in criminal proceedings. So, a confession made by an accused person is irrelevant in a criminal proceedings. If the making of the confession appears the court, yes, it is the correct answer is 24 to
30.
30. Okay, let me see. 30. Yes,
Yes, sir.
considerations of proved confession. Yeah, yeah, 24 to 30. Is it?
Yes, sir.
Okay, okay, and then I will make the correction for this one. This is correction. It is made. So now the confessions, confession, confe- confession from 24 to 30
30.
of, yes, section, we should write section 34 of Indian Evidence Act. The Indian Evidence Act 1872. Yes. Thank you very much for the correction, because sometimes I learn from you and sometimes you learn from me, because here I made a mistake. I made 80. I don't know where I got the point. Because when I typed it, then I found that answer. Anyway, come to the point. Next question is Kashmir Singh versus state of Punjab. సార్ ఈ ఎట్లా కూడా అడుగుతారా సార్, ఇది అడుగుతా కాదు, ఒక మోడల్లో చూసిన కాబట్టి నేను ఇది వేసింది ఇక్కడ. ఇది ఏవి 1920లో 2019లో వచ్చింది క్వశ్చన్. ఇది కాశ్మీర్ సింగ్ వర్సెస్ స్టేట్ ఆఫ్ పంజాబ్ వాజ్ డిసైడెడ్ ఆన్, అది బేస్ ఏ విధంగా అయి ఉంది, డైయింగ్ డిక్లరేషన్ మీదనా, కన్ఫెషన్ మీదనా, అడ్మిషన్ మీదనా? సో ఐ ఫౌండ్ ఇట్ ఈస్ ఏ not a dying declaration, but I said it is a murder because he was imprisoned over there, but later on he is acquitted in the case law. So that was the thing which I actually made. Now, a very famous case law, it is not on the screen, please, it is a subsidiary question. The subsidiary question which I am going to ask is, what is the leading famous case law in dying declaration? In the law of evidence, the Indian Evidence Act, yes, it is a very famous case law. Anyone? R versus Abdullah. What is the case law? R versus Abdullah is a very famous case law regarding the declaration. So where a person is not able to give the evidence in writing, he can also give the declaration by the or by the gestures. Yeah, that is the case actually. Because something disturbance happened over there. Okay, the time is up now. I am closing the today's class, and we will meet you in the next class tomorrow by following the another thing which is there. Yes, because yes, I'm closing down this thing. Yes, thank you very much for the patience listening, and we'll meet you again tomorrow at 10:15.
Thank you, sir.
Because this, yeah, because I exhaust the questions. Number one, number two, it is making a bit difficult for me to close also. Yeah, now I got it. Now I got it. Stop sharing. Yes, then Dhanyavadamulo, that is there. And okay, I will also close this thing. Good. Yeah, still it is not, yeah, now end of the meeting, right?